The regulations as currently drafted will impact equally employers who are looking to sponsor brand new H-1B applications or those employers that are looking to renew individuals who are already here in H-1B status.
Let's say I am at the end of my 3 years staying here in the United States, H-1B. I would like to extend. With the new rule, does the employer have to offer me a different salary? Do I need to negotiate a new contract?
With the new rule, again, depending on what the requirements are for the position that the company is offering, it may very well dictate or require a new salary based on the new wage levels. If you have a situation where a company is right now sponsoring a worker and just say a software engineer at a level 2 position, if you will, and the requirements of that position aren't changing, and now we go to do a renewal application, so it's still level 2, you absolutely will have a very material increase in that salary from what is currently there to what would then be the minimum amount required for the renewal. Now, there are situations where companies will pay above market. So for instance, you go through this process and you find out that the Department of Labor requires at a minimum that the company pay this employee in this occupational category $60,000. And maybe that company actually pays them 80 because that's what they pay similarly situated U.S. workers, which is the other part of the wage equation. And so now under these new rules, maybe now the new rules bring it right up to that. So it's still a level 2, it's still, you're still paying the individual worker the same amount. And so maybe there's no effect, but I think that'll be the exception rather than the rule.
What if I have a labor certificate already approved, but I have submitted my application with USCIS, however, USCIS is still reviewing my case. Will the new rules apply to my application?
So I think in that situation, number one, if your labor condition application was already approved prior to the effective date of the DOL's interim final regulations, then that wage rate that was reflected on that labor condition application will be set. And so the DOL portion of these new rules and regulations won't impact that petition. Now, the question would then become if USCIS hasn't ruled on it yet and adjudicated it yet, whether those degree requirements that we talked about, if that structure is going to apply to it. And so 2 things there. Number one, we have to get beyond that 60-day effective point when these regulations become effective from USCIS without legal challenge, et cetera. And then number 2, determine how and USCIS is going to implement those. So typically speaking, when agencies implement regulations like this, they'll issue some sort of frequently asked questions or some sort of policy guidance that says what they draw the line in the sand of when they're going to start adjudicating petitions for the new regulations. And so you have to have that official confirmation from USCIS as to how they would adjudicate petitions that are kind of in the hopper, if you will.
Okay. So right now we don't really have that. Now, one more case. If I am abroad and I am in the same exact position, I have the labor certificate earned and I have submitted the application. Does the same scenario, we're talking about the same case scenario here, the USCIS, it depends on the rules that are in effect when USCIS will review the application?
That's correct. Yep, it'd be the same situation if the individual is abroad, and the timing would roughly be the same as well from the regulatory perspective.
Okay.